Go ahead.
Thank you, Your Honor. Mr. Green, when was the last year that the Merlin II system was made, if you know?
I can speculate. I don't know the exact date.
Can you approximate?
Yes. It was taken out of production in probably the early 90s. 92, 93, maybe, 94.
And as far as the lines that we've talked about, those 8 lines, if an individual called from outside Neverland, called one of those 8 numbers, where would that phone ring, or where could it ring? Maybe to begin with that question.
Okay. It could ring at the 34 button in Mr. Jackson's living quarters.
Okay.
At the console.
All right.
And it could be programmed also to ring at any of the other telephones, if it was programmed to ring there. So it could ring at every single telephone, or only at 1 or 2. Typically, it rings at the console, or the 34-button phone. But it could ring, and you could do that on a line-by-line basis.
Okay. And do you know how this particular phone system was set up in terms of incoming calls?
No, because we weren't allowed to have any incoming calls ring in, so we could test that.
But typically it would be either the console or the 34-button phone.
Yes. On an estate situation, usually the calls are screened. They come into the console and are screened and then transferred to wherever they want to go.
Mr. Sanger used the example of a home phone system as far as similarity regarding listening into a phone conversation.
Yes.
Is this phone system really similar in terms of its barging capabilities?
Objection. Leading, Your Honor. Argumentative.
Overruled. You may answer.
It's different in that on the Merlin system, if you're barging in on a call, the person on the other phone would not know that you were. There would be no audio knowledge that they were being listened to.
So you could listen secretly without any audio input, on the phone line?
Correct.
And at a home system, when someone picks up the phone and is listening in, is there typically some audio input that is noticeable to the other 2 parties that are conversing?
More so,
And would the mute button also contribute to the secrecy of listening to those calls?
If you were using the speakerphone, yes.
Does the mute button also work on the handset microphone?
No.
Okay, so just on the speakerphone.
Yes.
As far as other people's ability to listen in on your conversations, is this system set up where any of the outside lines at Neverland, and I mean just the lines that don't involve either the 34-button phone or the phone at the office, could any of those lines listen in?
No.
So would that be another dissimilarity between home systems and this system?
Objection. Leading, Your Honor.
It's overruled. You may answer.
No, because you would have no way on the other phones of selecting the line, no. It has privacy. You couldn't, from any of those other phones, you couldn't listen in on another conversation.
All right, thank you. I have no further questions.
Okay, just a few. First of all, you could listen in on other lines on the phone system from the console in the administration building, correct?
That's correct.
And that console is pretty much out in the open, there, in the staff area of the administration office, correct?
Objection. Assumes facts, and no foundation.
Overruled. You may answer.
Well, when I inspected it, it was in a locked office.
When you say, a locked office, though, the administration building, the lock was on the front door of the administration building, correct?
No, there's an office inside the administration building, as I call it. I don't know if I'm, using the right terminology, but there was an office inside there that was locked.
That's your recollection?
Yes.
Did you take a picture of this?
The detective had to have the ranch manager unlock the door for us to go in.
All right, and there was a desk, somebody working at this area, correct?
There was no one in there.
I'm sorry?
There could have been. There was no one in there at that time.
Let me ask the question again, just so we're clear. It appeared to be a working area where somebody had a desk, correct?
That's correct, yes.
And the point is, whoever had access to that phone would be able to listen in on phone calls as well. Is that correct?
Yes, that's correct.
And you would expect, from your testimony, you would expect that that's one of the places that the phone would ring so that phone calls could be directed throughout the ranch, correct?
Yes. The lines all had to ring at the console. That was a must.
Alright, so not only could ring there, but you believe it did ring there at that console in the administration building, correct?
Yes.
The phone in Mr. Jackson's, what we call, it's a blank screen. I'm kind of pointing randomly here. The phone that was up on the board, what we call a junior console in Mr. Jackson's living area, the phone did not ring there. Is that correct, sir?
I don't know, because we didn't test any incoming calls.
Alright, and you can, as you said, you can program any of the other phones to be able to answer the phone from that location. Is that correct?
That is correct.
So if there was a phone, for instance, in that guard shack, you said you didn't go down and look, but assume there was a phone there that appeared to be one of the extension phones, you could program that phone to ring so that the person at the guard shack could answer the phone there, correct?
That is correct. Yes, sir.
Alright, you indicated these phones were last made in the early 90s, correct?
Yes.
But there are replacement parts and replacement phones that can be obtained if your equipment breaks down?
Yes, there's still refurbished equipment out there. There's millions of Merlin systems out there that was produced. It was the most widely sold telephone system in the world, and there's readily available parts.
Okay, and the most widely phone system, sold system in the world, this Merlin system, had that mute capability on all of the phones that were sold throughout the world, correct, if they were?
Yes.
If they were this kind?
If you were on the speakerphone.
Yeah, the speakerphone had it mute.
That is correct.
Now, almost all office or commercial kinds of telephone systems today, in fact, have that mute button. Is that right?
Yes. Oh, yes.
So there's nothing nefarious about that mute button, is there?
No, it's standard.
Alright, thank you. You did mention one other thing. You said something about an alarm system. Did you determine whether or not there was an alarm system in place at Neverland?
There was an alarm panel in the garage. And, I did not go into the alarm system to see what lines were attached to it, no.
Alright.
That wasn't my area of responsibility.
I understand. In your work in the telephone industry and as the president of a telephone company in Ventura, do you have occasion to work with alarm companies when they install?
Yes.
Alarm systems? And I think what we need to do, I've got to avoid talking over you. And if you could wait just an extra beat before you answer, otherwise the court reporter gets her fingers caught in the keys there.
Okay.
When you work with an alarm system, let me back up. When you go out to install a phone system at the same time that an alarm system is being put in place, do you work with the alarm company?
We do.
Alright, and one of the things that you often do is make sure that they have a telephone line, a secure telephone line, so that the alarm system can automatically call out to the alarm company or to a law enforcement agency. Is that correct?
That's correct.
Alright, and so you saw some phone lines that you thought the phone lines might, in fact, one or more of them might be associated with the alarm function at the ranch. Is that correct?
That's correct.
And based on your experience in installing telephone systems, is there anything unusual, in a large ranch property, for the owner of the property to have an alarm system hooked up to the telephone system?
No, you wouldn't have it hooked up to the telephone system. You would have a telephone line hooked up to the alarm system.
Okay, I'm sorry.
But you wouldn't have.
Let me withdraw that so I don't make it any more complicated. I understand what you're saying. So, what I meant was, have the alarm system hooked up to a telephone line. You've restated it correctly. Is there anything unusual, in a large ranch operation, whereby the owner of the property has an alarm system hooked up to a telephone line that goes off the property?
No.
And you've seen that. You've seen that in your work, correct?
Yes.
Is there anything unusual about the owner and the family having an alarm system around the immediate area where they reside to secure their own personal safety where they are living?
No.
So you see that from time to time, that there will be a system that's set up in the living quarters actually where the family resides. Is that correct?
Yes.
Alright, okay. No further questions.
Just one further question.
Yes.
Mr. Green, as far as this barging system works in the Merlin system as compared to a home system, is this barging system different only in the fact that it has a mute button? Or is there an additional feature that allows you to secretly listen to other phone calls?
Objection. That's compound, leading, and beyond the scope of recross.
Overruled. You may answer.
There is a bit of a difference. On the Merlin system, if I barge in, the party that I barge into cannot see any light, any visual indication or audio indication that I am listening, unless he hears some background noise in the back of me, or he hears me breathing.
So there won't be a click?
There won't be a click. There won't be anything.
All right, thank you. I have no further questions.
Oh, and on that, if I may, Your Honor, there's no reason. You have absolutely no information to suggest that this phone system was installed for the purpose of listening in on other people, do you?
No, sir.
In fact, it looks like a phone system that was installed sometime in the late 80s and has just been maintained there on this property ever since, correct?
Yes.
Okay, thank you. No further questions.
No further questions.
You may step down. Thank you.
Thank you.
Would you ask Mr. Feldman to come in, please?
We already did it.
He's on his way in from outside, but...
Come to the front of the courtroom, please. When you get to the witness stand, please remain standing. Face the clerk and raise your right hand.
I do.
Please be seated. State and spell your name for the record.
Larry Feldman. Feldman. Larry is Larry.
Thank you.
Good morning, Mr. Feldman.
Good morning.
You're an attorney licensed
Right.
to practice law in California?
I am.
And how long have you been an attorney?
Since 1969.
And would you share with the ladies and gentlemen of the jury your academic preparation to become a lawyer? Spare us the high school part. Just.
I went to, ultimately graduated from Cal State Northridge, where I'm proud to say I'm getting the Alumni of the Year award this year. And thereafter I went to Loyola University in Los Angeles, where I graduated in 1969 as the editor-in-chief for the Law Review and #1 in my class.
All right. And I assume you took and passed the bar?
I took and passed the bar.
And in your practice, where are you currently employed?
Currently, I am at a law firm called K. Scholer. Kayescholer. It is in Century City in Los Angeles.
And does it have offices in other locations?
It does. All over the world. Its main office is in New York, but it has offices in Shanghai, and Washington, D.C., Chicago, Los Angeles. I'm probably forgetting some.
What is the lawyer size of the firm?
About 600 lawyers.
Now, prior to the time that how long have you been with K. Scholer?
Since January of 2004.
And prior to that, what firm were you associated with?
Prior to that, I had my own law firm, which had different names from the time I joined it right out of law school. But ultimately as of January 2004, it was Fogel, Feldman, Ostrov, Ringler and Clemens.
And were you the senior partner of that firm at that time?
I was the head of that law firm.
Just give the ladies and gentlemen of the jury some idea of the type of practice of law that you're involved in.
I have been a trial lawyer all of my life. I started in this firm that I ultimately was the senior partner of right out of law school. I started trying primarily cases for injured federal workers, railroad workers and seamen. It was called the Federal Employers Liability Act, and the Jones Act. And I did other kinds of, automobile cases, but very rarely. Primarily I practiced a lot in federal court, some in state court, and tried a lot of cases in those years. And then slowly but surely my practice developed. I started doing a much broader array of cases, from representing labor unions, to representing people involved in wrongful discharge cases, African Americans who had been discriminated against big companies. Currently, right now, representing a class action in Washington, D.C., the largest class action of African Americans who have not been promoted appropriately. I represent, on the other side of the coin, I represent the Oakland Raiders in their many courtroom battles. I have represented a lot of entertainment people suing studios. I have defended studios. I have represented individual people who have legal malpractice claims against lawyers. And I have defended lawyers who have been accused of malpractice. I have sued rock groups and defended rock groups. And so my practice really has grown from what it once was into an array of cases, from really getting, at this stage of my life, some wonderful cases to handle as a lawyer.
And did you, at one time, represent the late Johnny Cochran?
I did represent Johnny Cochran for 10 years in a legal matter from the day, or thereabouts, when he became involved in O.J. Simpson till the end of that. Till 2000 and January 2004 I represented Johnny.
What professional organizations have you been associated with and participated in?
I was the president of the Los Angeles County Bar Association. I was the president of the Los Angeles Trial Lawyers Association. I was an officer in the American Board of Trial Advocates, which is an organization that you have to be invited into and have to have a certain skill level in trials and in representing people. I am what they call a fellow of the American College of Trial Lawyers, which is limited to 1% of the lawyers in the United States. Another organization that you have to be invited into to get into. The International Academy of Trial Lawyers, where I am, which is limited to the top 500 lawyers, theoretically, in the world. I mean, I don't know who's making these judgments, but that's sort of.
It's nice to be invited, even though you don't understand the standards.
It's one club you want to be invited into. But I'm sure there's somebody else who deserves to be in this club who for some reason doesn't get in.
And are there some committees that you operate in on a statewide basis?
Yes. I've been appointed to, by the governor to assist in selecting judges for the Southern California area. I have been appointed by the Chief Justice of the California Supreme Court, both Chief Justices, Malcolm Lucas, who was the Chief Justice originally, who had a blue ribbon committee of lawyers throughout the state, with judges, who are trying to improve the system of justice so there would be better access to the court for people. Fancy people, big corporations, don't have any problems using the courts. But little people have a lot of trouble getting through these courts, and the Chief Justice had a committee, as we moved into the millennium, to try to figure out how to better access courts for individuals who couldn't hire fancy lawyers. And then just recently the current Chief Justice of the Supreme Court asked me to be on a committee to help with the discipline of lawyers. There is a lot of criticisms that lawyers who should be disciplined aren't disciplined and that the public doesn't feel like we're disciplining our own lawyers. And the state bar is in charge of this system as it exists right now. And there are these state bar judges who judge it, and I've been asked to be on this committee to look at these issues and try to develop a better system for making sure that lawyers who need to be punished are punished and that we have the right people in place who can punish them appropriately.
And have you done some teaching in your spare time?
In my spare time, when I'm not in Santa Maria testifying, I do. I taught last week at Loyola. I do a lot of teaching to judges, to lawyers, to law students, on different things about the law, from ethics, to how to try a lawsuit, a whole potpourri of different things. I've written a lot about articles and chapters in books about how to try lawsuits or some aspect of some part of a case that I may have tried.
Let's turn to a specific case, if we can, and I'd like to focus your attention to the year 1993 and 94, if we can. Are you familiar with a then young boy by the name of Jordan Chandler?
I am.
And how did you become involved? By the way, did you know, when you first met Jordan Chandler, do you recall how old he was?
He was 13, as I recall.
And how did you become involved with Jordan Chandler? Tell us.
Objection to the extent it calls for hearsay.
Calls for a narrative. Sustained.
Well, describe to us, then, the first contact you had with regard to Jordan Chandler.
A lawyer.
Same objection. To the extent it calls for hearsay, I'm going to object.
Overruled. You may answer.
A lawyer in the community referred the parents, and, are we using his name?
Yeah.
We're using his name?
Jordan Chandler, yeah.
Okay, who used Jordy? Who brought Jordy to me? A lawyer who was representing the father of Jordy at the time. If I recall, Jordy was being represented at the time, for like 20 minutes or so, by Gloria Allred. They wanted to switch lawyers. And he asked me to interview the family, and I did.
And as a result of the interviews and what other actions you also took, did you eventually end up filing a lawsuit against the defendant in this case, Michael Jackson?
I did.
On behalf of Jordan Chandler?
I did file a lawsuit.
On behalf of the family also, members of the family?
You know, without seeing the lawsuit, the mother and father, if I recall correctly. I could be wrong about this, without seeing the lawsuit. I thought the mother and father were just the guardians and didn't have their own claims that we asserted. I don't think we ever asserted any claims on behalf of the mother and mother. We just asserted them on behalf of Jordy. And the parents in the Chandler case were divorced, and there was a lot of acrimony between mom and dad, and in order to keep peace between mom and dad, I came up with the idea that there should be a joint guardianship, and I think that's what we did.
Alright, with regard to that particular case, which would have been, I guess, Chandler versus Jackson, correct?
It was.
That would have been the heading? You did file a formal lawsuit?
I did.
And what jurisdiction was that lawsuit filed?
Los Angeles Superior Court.
And in that particular lawsuit, do you remember how many causes of action you alleged?
I think 7, roughly 7 causes of action.
Relevance, Your Honor.
Overruled. You may proceed.
And with regard to the causes of action, what was the nature of the causes of action alleged against the defendant Mr. Jackson?
The sexual molestation of Jordy Chandler.
Now, did that particular case, the case of Chandler versus Jackson, eventually result in a settlement?
There was.
And with regard to that particular settlement, was there a particular form that the settlement took?
Form, meaning a contract?
Well, a contract or some other document too.
Yeah, there was a lot of documents that surrounded that settlement.
And with regard to the settlement, was it? You've heard. I'm sure you're familiar more than I am. The term, confession of judgment.
Yes.
Was that particular form of document used in the settlement of the Chandler versus Jackson lawsuit?
Objection. Relevance.
What's the relevance, counsel?
The form of the settlement in terms. I mean, the form of the settlement. Do you want me to go ahead and speak out, or do you want to approach the bench?
I asked you the question.
Alright, then as I understand it, there are settlements that are done by way of contract, and there are settlements that are done by way of confession of judgment.
What's the relevancy?
The legal effect of the judgment, plus the.
Alright, you may ask the question.
Alright, you're far more capable than I am of delineating the differences, but is there a difference between a civil settlement that results from a contract and one that results from a confession of judgment?
Yes.
Alright, would you explain to the jury what the difference is and what the legal effect is?
Yes. In a confession of judgment, it is as though we went to trial and had a lawsuit and the jury came back with a verdict and we had a judgment, or the judge came back with a finding. And when the judge says somebody's at fault, and, here's your damages, you put it into a judgment. And when you have a judgment, you can file that judgment in the county and then you can execute on that judgment, so that if, and just as an example, and I'll just make this number up, let's say you had it for $1, a judgment for $1. Well, if you have a judgment, you could just go and take somebody's house or take somebody's car, or go to their bank account and literally take that dollar out to satisfy the judgment. If you just have a release or a contract, then all you get left with, if the person doesn't pay you the dollar, is a something that says, I promise to pay you $1. And then you got to start all over and prove that person breached that contract. So in the Michael Jackson case, because there were payments going to take place.
Let's stay away from all that area, okay? Just tell us about.
Alright, well, that's the best I can tell you the difference.
Alright, but in the Michael Jackson case, you got a confession of judgment?
I got a confession of judgment.
Now, with regard to the case of Chandler versus Jackson, all right.
Yes.
You told us the causes of action involved child molestation, correct?
Correct.
Had you handled other child molestation cases prior to the Chandler versus Jackson case?
The answer is, to the best of my recollection, I had never handled what I would call a civil child molestation case sexually. If what you're asking, I don't want to. I did handle, on the defense side, a family that was accused of abuse of a child.
Physical abuse.
It wasn't sexual abuse. So, if the question is sexual molestation, to the best of my recollection, I have never handled a sexual molestation case before Michael Jackson and since Michael Jackson.
Now, at the time that you were representing Jordan Chandler back in 1993 and 94, were you aware, your own personal knowledge, whether or not the Los Angeles County District Attorney's Office was involved in investigating the sexual abuse allegations against Mr. Jackson?
I do, and they were.
And of your own personal knowledge, were you aware of the fact that at some point in time later, that the Santa Barbara County District Attorney's Office joined that investigation?
Yes.
During the time that you were representing Mr. Chandler, the child Chandler, not the father Chandler, the child, Jordan Chandler, during the time that you were representing him, were either, let's just go one at a time so we don't get a compound problem. But was the Los Angeles District Attorney's Office given an opportunity to talk to your client?
The Los Angeles County District Attorneys, they talked to my client, they certainly did. They talked to him all they wanted.
And then later, when the Santa Barbara District Attorney's Office joined in the investigation, were they allowed access to your client for interview purposes?
I mean, I could be wrong. I think you were. Or I don't know about you, but I thought you were. I thought, but I don't remember that, frankly, whether you were or you weren't. I know when the police wanted to talk to Jordy during that period of time, they had access to him, so which ones I can't recall.
Was there a time in which there was a request for your client, Jordan Chandler, to appear before the Santa Barbara County Grand Jury?
Gee, I can't remember that really. There may have been. I just don't remember.
To your knowledge, did your client appear before the Santa Barbara County Grand Jury?
I don't think so.
Was there some point in time where your client decided that he did not want to participate in an investigation by
objection, relevance, foundation, and calls for speculation?
Sustained.
Are you aware, as a practicing lawyer in the state of California, that a juvenile who has been the alleged victim of a child molestation cannot be forced to testify?
Objection, leading, and relevancy, and misstates the law.
No, it doesn't, Ms. I'm asking his professional legal opinion, Your Honor.
Calls for a legal conclusion.
I'll allow the question, but I'm going to have you rephrase it because of the way you asked it. I'll allow this subject matter to be questioned.
With regard to your practice of law and in your civil litigation, and with regard to your representation of Jordan Chandler in the Chandler versus Jackson lawsuit, okay.
Yeah.
Were you aware or did you become aware of the fact that there is a code section dealing with a minor's right to refuse to testify in a criminal prosecution?
I was aware of one in '93.
And you were aware of that while you were representing Jordan Chandler?
I was.
Speak more into the microphone.
What do you want me to do?
Speak more into the microphone.
Oh.
Now, I guess the last question I have, and I'm probably taking it too much for granted, but with regard to the lawsuit involving Chandler versus Jackson, was that resolved in Chandler's favor?
Objection.
It was. Oop.
Move to strike. Vague. No foundation. Calls for speculation.
Overruled.
You may answer.
It was absolutely resolved in Jordy Chandler's favor.
All right, let's fast forward, if we can, to the year 2003. Are you familiar with an attorney by the name of Bill Dickerman?
I am.
And have you ever had contact with Mr. Dickerman?
Before then or?
No, in 2003.
Yes.
Had you ever had any prior contact with Mr. Dickerman of any kind?
Yes, he, I believe, tried to refer me a case or cases in the past. Most of the cases I get are from other lawyers who refer me business, and I know that he did. I can't remember what the case was about, and I know I didn't take it, but at least on one occasion, if not more, he had called me and asked me to help him in cases that he was involved with.
Okay. Now, before we get too far down the road with Mr. Dickerman, I neglected to show you a photograph. Your Honor, I've had a photograph marked as 776 for identification purposes. I'm approaching the witness. I've shown it to counsel. Mr. Feldman, do you recognize the person depicted in that photograph?
I do.
Who is that?
Jordy Chandler.
Is that an accurate depiction of what Jordy Chandler looked like?
He was much better looking, I can tell you, at that age. He was adorable. That's kind of blurry.
Objection. Move to strike the gratuitous remarks.
Stricken.
Move that 776 be admitted into evidence, Your Honor.
No objection, Your Honor.
The answer was stricken to the question as to whether or not it was an accurate picture of Jordan Chandler. That hasn't been answered.
I thought you were just striking the last part.
I struck the whole thing.
Is that photograph, 776, an accurate depiction of Jordan Chandler at or about the time that you knew him?
Yes.
All right, it's admitted.
May I publish it, Your Honor?
Input 4, Your Honor.
Yes.
All right. Mr. Feldman, the exhibit that is on the Elmo there, 776. That's the one you just identified as the individual depicted as Jordan Chandler, correct?
That's correct.
All right. Thank you very much. Now, let's get back to Mr. Dickerman. You indicated that you had at least one prior referral from him that you recall. Now, let's just talk about something in general. You say you get a referral. Is there ordinarily, in the practice of law when somebody refers you a case, an agreement called a referral agreement?
Yeah, depending on what kind of case, obviously, that's being referred, but the answer is yes.
Could you explain to the ladies and gentlemen of the jury how that referral agreement usually works, in general terms?
Yeah, sure. There are two ways, generally, lawyers make their money. One is a contingent fee agreement, where they only receive payment if they are successful. And if they're not successful, they don't get paid. The second is just a straight hourly kind of payment where you get paid for every hour that you work. In the contingent field, when a lawyer refers another lawyer in the contingent field, some lawyers, not all, want to participate in some fashion, some way, and they then request the referral fee. And the state bar rules say that's legal and you can do that, as long as you tell the client in advance and the client consents to that referral agreement.
Now.
And it's traditionally done. Not traditionally, but depends where the case is coming from and who the lawyer is, and, it's a whole variety of things.
In 2003, did Mr. Dickerman refer you a case?
He did.
And with regard to that particular case, was there one of these referral agreements formed between you and he?
Ultimately, yes. Not right at the beginning. But ultimately, yes.
As part of the referral process, did you have a conversation with Mr. Dickerman?
Yeah, I'm sure I did. I must have.
The first contact was by phone?
Oh, yeah, the first contact with Mr. Dickerman clearly was by phone.
And did you eventually have an in-person conversation with him?
In general, you're not talking about the referral fee now. You're talking about just.
Yeah, I'm talking about.
In general, yeah, sure. I mean, he called me. He told me stuff. He then wanted to come in and talk to me.
Objection. Hearsay. Move to strike.
Sustained.
I'm not going to say what he said.
I know, and you didn't. Okay, so he had a telephone conversation with you, and he told you some things over the phone?
That's right.
All right. As a result of that telephone call, did you then have an in-person meeting with Mr. Dickerman?
As a result of that, I had an in-person meeting, yes.
Do you recall whether or not, at the time that you had the first in-person meeting with Mr. Dickerman or the first meeting in person, the sentence the other way was bad, with Mr. Dickerman?
Yes.
Do you recall whether or not the clients that he was referring to you were present?
I don't think they were in the first meeting.
Now, at some point after that, then, did you meet the individuals that were the subject of the case referred to you by Mr. Dickerman?
Yes.
And with regard to those, the clients, do you recall their names?
Yes.
Who were they?
Janet Arvizos, her daughter Devellin, her son Gavin, and her son Star.
Now, let me go back. I neglected to ask you one other question about referral agreements. Does the fact that you take a referral agreement from another lawyer obligate you to continue that case to a point of filing a cause of action or taking some form of action?
Absolutely not. Absolutely not.
You had a meeting involving the family where you met them?
Yes.
Do you recall whether Mr. Dickerman was present or not?
My guess is he was, because I assume he brought them to me and brought them to my office, and he had contact, a lot of contact, with them before he came to me, so I'm assuming he did. I'm almost sure he was there. I would never have met with them without him being there.
And do you recall where the meeting took place?
In my office. This is when I was at Feldman. This is not my new job, but when I had my old law firm.
Where was that office located?
In Santa Monica.
Now, as a result of that first conversation with the Arvizos family, did you decide to take a course of action of any kind?
Well, sure, of some kind.
All right.
I mean,
what would you categorize, in terms of the way you handle cases, as the process that you felt was going on at this point?
The process that I follow in my law office at all times is people come in, they tell the factual story. We then, depends on the case, but generally speaking we then will do research, legal research, especially in a case like this, to see and try to understand what the law is. And because of the nature of the potential defendants at that time, which was ABC, this Martin Bashir, whatever his company was called, it involved Michael Jackson, we were going to make sure we knew what we were doing before we started. And so after we sort of heard this version of the facts, of some facts anyway, that's the next step that we did. We also, I think, we were shown letters. Mr. Dickerman had letters that he had written to the BBC in England, and he wrote letters to Mark Garrigus, and Garrigus to him. I can't recall which way they went, but, so we had those, and we were trying to make heads or tails in a legal sense, which nobody had done up to that point in time, to try to focus on what is this about and where are we interested in taking any more steps.
Now, with regard to the legal research that you did, what was the research that you did?
We had to research. The fundamental issue was that Martin Bashir had done a tape at Mr. Jackson's house that Ms. Arvizos had told us.
Objection to the extent it calls for hearsay, as well as narrative.
Sustained.
Just what are the issues that you were researching as a result of your conversation with the Arvizos family?
Well, whether or not Martin Bashir or ABC had to have consent to put the children on television.
Now, with regard to other aspects of the information provided to you by the Arvizos family in this meeting, did you decide on another course of action that you felt you needed to do to determine whether you were going to represent this family?
Objection. That's leading. Move to strike.
Overruled. You may answer.
Yes.
And what did you do in that connection?
I decided at some point in time that I had to make some heads or tails out of what was being told to me by Mrs. Arvizos, by Starr, the young boy, and Gavin. And I concluded that I wasn't going to be able to do.
Objection. Move to strike. Impermissible opinion. No foundation. Relevance. Hearsay.
Judge.
The question, though, was what did he do next, so he answered that. So his thoughts aren't being called for at this point.
Judge. I believe under 1250 of the Evidence Code.
This just relates to the question and answer, counsel. The question didn't call for his thoughts. Don't look at me like that.
Judge. I was thinking of the next question I was going to ask. If you took it the wrong way, I'm sorry, but I wasn't.
All right, go ahead.
I mean, it's... All right, so you decided on a course of action?
I did.
As a result of the information given to you?
Yes.
And what was that course of action?
The course of action was to allow an expert, which I was not, to spend some time with all three of them. Devellin wasn't really the issue, but Janet, Starr and Gavin, and let some expert figure out, if he could, what was happening.
All right. Did you contact somebody to help you make that evaluation?
I did.
And who was that?
Dr. Stanley Katz.
And were you familiar with Dr. Katz prior to the time that you decided to use him in the case?
Yes.
Involving the case that Mr. Dickerman had referred to you?
Yes.
And what was your prior contact with Dr. Katz?
In 1987, I was defending a family who had been wrongfully accused of abusing a child, and the court so found, and Dr. Katz, the first time I met him, was an expert that we hired for the defense to assist in that trial, and he testified in that case.
Did you hire Dr. Katz or did he participate in the case of Chandler versus Jackson?
Yeah, in Chandler versus, participate. Chandler versus Jackson moved very quickly, because he was a minor.
Did you retain him?
So I retained him, yes.
And did he play any role in the case itself? It never went to trial, correct?
The case never went to trial. We never got that.
Objection. Asked and answered.
I'll move on, Your Honor. It's not a problem.
All right.
As a result of your contacts with Dr. Katz, did you decide to send the Arvizos family to Dr. Katz?
Yes.
In 2003?
Yes.
Okay. Now, do you recall when that was, approximately, what month it was?
Either May or June, in that time frame, of 2003.
At some point in time, did you receive a report back from Dr. Katz about his initial contacts with the family?
Oral. I had an oral conversation with him.
Do you recall whether it was in person or over the phone?
I think it was in person, quite frankly. I think he came to my office.
Now, after you received this report, did you do anything?
Yes.
What did you do?
I called the Arvizos family, Mrs. Arvizos and the 3 children, back into my office for a meeting.
All right. And in that meeting, what was the topic discussed?
Objection to the extent it calls for hearsay.
All right.
Overruled. The subject matter only.
The subject matter only. The subject matter was the options, well, what Dr. Katz had told me, and the options that existed at that point for that family. Different courses of action that were available to them at that point in time.
Your Honor, at this point I would ask the court to be able to have the witness be able to recount those, and that it would be admissible under 1250 of the Evidence Code not only as to this witness's state of mind, but also as to the state of mind and actions of the Arvizos family.
And I object. Hearsay, foundation, relevance, and calls for improper conclusion, and 352.
Whose statements are you offering for the state of mind only?
Your Honor, both. I mean, you're asking me, so I guess I can go beyond.
Just give me names.
All right. This witness, Mr. Feldman, with regard to his state of mind with regard to what the future of any lawsuit may be at this point. And secondly with regard to the Arvizos, any decision that they would have made regarding any lawsuits against any individuals at this point in time, which I believe is an issue in this case.
The objection is sustained.
As a result of your conversation with the Arvizos on this particular day, what was the next step that you took in evaluating this case?
Well, the next step I took was, I won't say what I said. I understand the ruling. They went back and saw Dr. Katz again. And I then went to the head of the.
Let's just stop there for just a second, Mr. Feldman.
All right.
So as a result of the conversations that you had with the Arvizos, there was a decision to go back to see Dr. Katz with the family again, correct?
Their decision that they wanted to go back and see him again.
Okay. And to your knowledge, did that happen?
Yes.
And to your knowledge, did you then find out the results of Dr. Katz's subsequent conversations with the family?
Yes.
And as a result of those conversations with Dr. Katz, did you decide on a further course of conduct that you felt needed to be done?
Objection. Leading.
Overruled.
Yes.
You may answer.
What did you do?
I then believed that Dr. Katz believed he had a report, and I then went to the head of.
Objection. Move to strike. Hearsay.
His belief is stricken. The question is, what did you do?
I went to the head of the Department of Children's Services, Los Angeles County, a fellow by the name of David Saunders, who was the head of the Department of Children and Family Services.
And did you contact him prior to going down to the department?
I did.
By what form?
Well, that's a good question. I contacted him first between the meeting where I called the Arvizos into my office after Dr. Katz talked to me and before they went back. I talked to him and alerted him to a possibility that I might need to talk to him.
And then after that?
And what I can't remember is if I saw him at a social gathering where we were both at, or did that by phone. It was one or the other, but I definitely met with him or talked to him and told him that. I didn't tell him what it involved. I just told him it was a high-profile thing, and if it happened, I needed to have secrecy.
All right. Now, with regard to after your second conversation with Dr. Katz, did you actually go down to the Los Angeles County Department of Child and Family Services?
Yeah, well, I did then definitely call him and talk to him again.
Before you went down there?
Before I went down, and then after talking to him and telling him what it was.
Objection. Move to strike. Asked and answered.
Sustained. Well, not asked and answered, but it's not responsive.
So you had a telephone call with him?
I did have a telephone call.
And after that telephone call, did you go down there, and with whom?
I went down there with a colleague of mine from my office and Dr. Katz.
And what was the purpose for the three of you going down to the LA County Department of Child and Family Services?
I wanted to get absolute assurance from the head of the department that there would be no leaks of anything that they decided to do or not do in connection with the report that Dr. Katz was going to make.
Now, are you familiar with the law in the state of California that requires certain psychologists or psychiatrists to make a mandatory report?
I am.
When they suspect child abuse or child.
Objection. Leading. Move to strike.
Overruled.
I am aware of that.
And was this the purpose for the three of you going down to the LA department?
The purpose was for him to report, but he could have done it on a hotline like was done in '93. This time it was to have it guaranteed it was never going to leak out to the press.
Okay. Now, as a result of this conversation, were you directed to another agency?
Well, he directed me into a room with two people. That's where he directed me.
You had a conversation with those people?
I had a conversation with those people.
And as a result of that conversation, were you directed to another agency? Let me put it this way. Did they take the report?
They didn't take the report, and they didn't direct us to another agency. They.
Objection. Hearsay. Move to strike.
Overruled.
Now, after you left the agency, did you decide on a course of action?
Yes.
And was this regarding and connected with Dr. Katz's responsibility as a mandated reporter?
Yes, because I felt he still hadn't reported because they didn't take the report.
Objection. Objection. Move to strike. Non-responsive.
After yes is stricken.
All right. Who did you call?
I called you.
Okay. And as a result of that conversation, were you eventually contacted by somebody else?
My recollection is that I was contacted by a police officer. Or he may have been a sheriff. I don't know what he was, but he was some law enforcement person.
Now, during the course of the conversation between you and I, did the subject of a civil lawsuit against Michael Jackson in connection with the substance of the mandated report come up?
Yes.
Objection. Leading.
Overruled. The answer was yes.
And in that connection, was there a representation made by you to me concerning a civil lawsuit?
Yes.
Objection. Leading.
Overruled. The answer was yes.
And with regard to that representation, and, Your Honor, I'm offering this under 1250 what was said by you to me.
No lawsuit. I would not file a lawsuit. And there was no plans to file a lawsuit. And that you would investigate it and make up your own mind. Not you, but the police.
Now, do you currently, at some point in time did you feel you represented the Arvizos family in some kind of litigation?
That's a great question. I've thought about it. Yeah. I mean, yes, I guess, I don't know about some litigation. I certainly represented them in everything I did, because I'm a lawyer and I was doing it as a lawyer. So, yes. The answer is yes.
With regard to the information and the substance of the original conversation with the Arvizos family, did you feel that you represented them at least at some point with regard to the exploration of the issues involving the Bashir tape and things of that nature?
Yes, for sure.
And was there a certain point in time where that representation ended?
Yes.
And when was that?
Approximately. I terminated them. My relationship with them sometime in October, I think, if not sooner. I think effectively it was August or September, somewhere in that time, of '03, and then shortly thereafter I wrote a letter terminating my relationship, confirming that I was not their lawyer and that I wasn't going to proceed with anything.
And at any point in time from the time you first met the Arvizos family and to the time you wrote the letter saying you were not going to represent them, which would have been somewhere around October of 2003, did you ever file an action on their behalf?
No, never have.
Now, subsequently, in the year 2004, you did some legal work for the Arvizos family, correct?
Yes.
And you have made appearances in court on representing the family, is that correct?
Well, I haven't physically made any appearance, but I have occasionally done things, very limited, for them.
And have you done that for other clients before?
Oh, yeah, I was.
Is there a term in the legal profession that we call that?
Yes.
What's it called?
Dumb.
That wasn't exactly the one I had in mind.
Pro bono. Pro bono. Stupid.
And do you consider what you did with the Arvizos after the point that you were no longer officially their lawyer to be pro bono work for the family?
Yeah, absolutely. I never expected to get paid, and I've done very limited stuff, and the stuff that I've done is just stuff that I felt that I should do. That nobody was going to do it for them, and I got this thing rolling and I ought to do it, and I have very limitedly done things.
Is one of the things that you did for them was to file a claim with the Los Angeles County Department of Child and Family Services?
That I did for both of us, because I was upset that the county did that, so we filed a claim.
Why did you file a claim against Los Angeles County on behalf of Janet Arvizo?
Because the County of Los Angeles has a sworn obligation to protect children. And here, they swore. I went to the head to get this thing protected, and the minute Mr. Jackson gets arrested, the first thing that happens is that county leaks out a report that was created and written after he was arrested, a memo. It comes out, it quickly gets on the news, and quickly blasts this family. And I thought, of all the things that I've seen as a lawyer.
Objection. Move to strike. Non-responsive. Giving a narrative, impermissible opinion.
It is responsive, but it is a narrative answer. So I'll sustain the objection.
All right, so with regard to this particular claim that you filed, it's not a lawsuit, right?
It was a claim.
And that's required when you sue a governmental agency, to file a claim first?
Yes.
And then what is we've heard this term thrown around in the courtroom in relationship to other things. What's the statute of limitations for an individual to actually bring the lawsuit once the claim is filed?
You have 180 days to file the claim from the event. And then, so you have to have a claim on file if you were ever going to do anything. And then once they deny the claim, you have another 180 days, essentially, to bring a lawsuit once it's denied.
And as a result of that claim that you filed on behalf of Janet Arvizo, has the second 180 days elapsed?
It has as to Janet, and it has as to Devellin. I don't think it has, frankly, as to the minors. But it certainly has as to, Janet couldn't file a lawsuit today and her daughter couldn't file a lawsuit today.
And that's because they have a certain number of years after they reach the age of majority, 18, to file a claim or a lawsuit.
That's my understanding. Once they file a claim, it protects their rights, I think. You know, this was a claim that asked for an apology.
So they were never seeking monetary damages?
Well, who knows? But, they're really.
Objection. Move to strike.
I don't know what.
Just a moment. The objection is sustained. Any answer is stricken.
At the time that you made the written claim to the County of Los Angeles, did you demand monetary damages?
It probably said words in there, whatever the damages are. It didn't have a number, I can tell you that. And it had, you can't file a lawsuit without the claim. There's no such thing as a lawsuit for an apology. So it said if I saw it, if you had it, I could tell you, but it was really to get the county to do something, for the next kid.
Move to strike the gratuitous remarks at the end. Non-responsive. Impermissible opinion.
I'll strike the last sentence.
During the time that since you first met Janet Arvizo.
Yes.
And the Arvizo family, were you ever asked to file a lawsuit against Michael Jackson?
Objection. Move to strike. Calls for inadmissible hearsay. No foundation.
The objection is overruled. You may answer.
I have never been asked to file any lawsuit against Michael Jackson.
Nothing further, Your Honor.
May I take just a second, Your Honor? I have to get some materials. Good morning, Mr. Feldman.
Good morning, sir.
Mr. Feldman, if Gavin Arvizo decided at some point in the future to sue Mr. Jackson for alleged sexual abuse, how much time would he have to file that action?
I think he'd have till his 20th birthday.
If Star Arvizo decided in the future to sue Mr. Jackson for alleged sexual abuse, how much time would he have to file that lawsuit?
I think the answer's the same. 20.
If, at the end of this trial, they were to decide, we'd like to sue, they'd have plenty of time to do it, wouldn't they?
They, meaning the boy.
Gavin.
Not Janet.
Gavin and Star.
The two boys?
Yes.
If they wanted to at the end of the trial, they could sue, sure.
Isn't it true that a judgment of conviction in a criminal case for anything related to child molestation could be dispositive in a parallel civil suit alleged for the same facts?
As long as it's a felony conviction, that's right.
In other words, if Mr. Jackson were convicted of felony child molestation in this case, either Gavin Arvizo or Star Arvizo could use that conviction to essentially win a civil case regarding similar alleged facts against Mr. Jackson?
That's correct.
If there were a conviction for felony child molestation in this case, and if Star or Gavin elected to sue in a civil case based on the similar alleged facts of sexual abuse, Essentially, the only issue remaining would be how much money you get, correct?
Probably. I think it's close enough. I mean, nothing is that simple, as just stated. You know it as well as I, but essentially I think that's what would happen.
Well, you would have to follow certain civil procedures in civil court, but essentially, Mr. Feldman, you could take the judgment of conviction, you could walk into civil court, you could lodge it with the court, you could ask a judge to determine that liability has been established, true?
Yes. You get these problems with appeals, and the impact of appeals, and it's a complicated thing, but the answer is ultimately yes.
And one of the reasons for that is that the burden of proof in a criminal case is proof beyond a reasonable doubt. The burden of proof in a civil case is preponderance of the evidence, and if you have proof beyond a reasonable doubt, you automatically have proof by a preponderance of the evidence, as you would need to have it in civil court, true?
That's the theory.
Well, that's correct, right?
Yeah, that's the theory behind it.
Alright, now, let's assume there was a conviction in this case and that Mr. Jackson were convicted of felony child molestation, and let's assume that Gavin and Starr then decided, we want to file a civil suit for millions of dollars in civil court, okay?
Yeah.
On similar alleged facts. And let's assume the process you've just identified, where you walk into civil court, you follow rules, and you essentially establish to a civil court judge that liability exists. If that were to happen, whoever the civil lawyer was representing the Arvizos would have avoided costs of investigation, experts, depositions, filing fees, messenger fees, all sorts of legal fees, right?
Well, look, I don't want to open that hypothetical. You'd have to be nuts to do that, what you're saying, as a civil lawyer.
Sir.
You'd have to be nuts.
Sir. Did you tell a grand jury in Santa Barbara County that you had incurred tremendous costs of expenses during your lawsuit against Mr. Jackson in 1993?
I did, and it was true.
And if liability were established through a criminal conviction, a civil litigator could avoid most of those costs, correct?
Some of those costs. Not most. Some. I mean, certainly some you would avoid.
You could avoid a lot of investigative costs, correct?
You know, can I?
Just answer my question, if you would, please.
I can't answer it that way. If I could explain to you why. You know, I'll tell you why I can't, and you can ask me the next question and you can get to the answer.
Is your answer you would not avoid investigative costs?
No, it's the amount of investigative costs we're talking about.
Okay. Did you tell the jury today that when you were in front of the grand jury you mentioned the enormous amount of expenses and legal fees you had incurred in 1993 litigating that case until it settled?
Object. Asked and answered, Your Honor.
I'll sustain the objection if you're asking him what he previously testified to.
Yes.
Today. I mean, you're saying, what did you just testify to on direct?
I couldn't, to be honest, Your Honor. I couldn't tell if he had actually addressed that issue. It's a long answer.
I'm happy to. The legal fees wouldn't change. The costs would change. We're just debating how much those costs change. But the costs would change. The legal fees would be the same. If you're on a contingent fee, you don't get paid any more if you work a lot or work a little.
But if you were to gauge your legal fees at hours, sir, and you didn't have to prove liability, you would save a tremendous amount in legal fees, wouldn't you?
Well, sir, I keep trying to tell you, that ain't the way it works, and you want to keep saying it is. Now, I can tell you how it works, and then you can get to what you want to get.
If you had to try a civil case on liability, Mr. Feldman, it could go months, couldn't it?
Sure.
If you have a judgment of felony conviction in a criminal case and you walk into civil court and establish it, you don't have a trial in civil court for months on liability, correct?
You have to.
Yes or no?
You could, if you know, you could. I can't answer it the way you want me to answer. I'm happy to explain it to you, and maybe we can get to the answer.
Would a judgment of felony conviction in criminal court possibly eliminate a trial on liability in civil court for similarly alleged facts? Yes or no?
Do you count punitive damages in liability, or not?
Sir, I'm asking you to answer my question.
Well, I can't answer it this way. Liability has a lot of aspects to it, sir, and one of the things is the finding of malice.
Okay.
And that's separate from what you're talking about.
In other words, if you could avoid the liability phase of a civil case, you wouldn't save some time in legal fees?
Of course, you would save some time, and you would save some money. We're just talking about how much. You keep saying it would be a total saving, and I'm trying to explain to you that's not what would happen. It wouldn't go down that way.
You wouldn't have to prove liability, because it would have been proven in a criminal court, correct, or not?
You'd have to prove malice, though.
Correct or not, Mr. Feldman?
Well, how many times can I go through this with you?
Are you saying if you get a judgment of conviction in criminal court for felony child molestation and you then walk into civil court with civil allegations based on the same facts, you still have to establish liability? Is that what you're saying?
Not liability as to that aspect. But for malice, you would still have to prove it.
Okay, alright. Now, what is the statute of limitations for civil fraud?
Civil fraud?
Yes.
3 years from discovery.
Okay. Were you aware that attorney William Dickerman wrote letters on behalf of Janet Arvizos to attorney Mark Garrigus alleging fraud?
Not sitting here. I thought it was over their belongings, or something, that he wrote letters.
You thought the letters were only about belongings?
You know what? I don't know. I'm guessing. Show me the letters and maybe it will refresh my memory. I remember there was letters to Mark Garrigus, and that's what was significant to me. What was in them, I can't remember, unless you show me the letters.
Do you recall at some point during your relationship with Prosecutor Sneddon, Mr. Sneddon spoke to the media and said, if they're going to sue, I hope they don't do it until after the criminal case is done.
I'm going to object to the word relationship.
I don't even remember it happening.
Just a moment. You're asking him what Mr. Sneddon said, if he
was aware of it.
That's not how you phrased it.
No.
I'll sustain the objection.
Mr. Feldman, Prosecutor Sneddon asked you about a technical term in civil litigation called confession of judgment.
Yes.
Right?
Right.
Now, in the civil case where you represented Mr. Chandler and his parents against Mr. Jackson, there was a cross-complaint, was there not?
There was?
Mr. Jackson sued for extortion, didn't he?
I don't know. I know that his investigator, Mr. Pelicano, claimed extortion.
You don't recall?
I'm not saying it didn't happen. I just don't recall.
Okay, and typically, in a settlement like the one described by Prosecutor Sneddon, if someone agrees to pay money to the other side would like the payment of that money secured by what is called a confession of judgment, correct?
That's right. When it's paid over time, that's correct.
Okay, and the purpose of a confession of judgment is that if the paying party stops paying, you can run into civil court and obtain what is called a certified judgment so you can then collect on their assets?
Correct.
Right?
That's right.
And if you didn't have that confession of judgment, your only remedy would be to then file another lawsuit for breach of contract, correct?
That's right.
So what Mr. Sneddon was talking to you about was ways that you have to collect money that you're owed in a settlement, true?
I don't know what he was talking to me about. He asked me questions, and I answered the best I could. What you've said is true, and that's what I thought I just said.
And typically in a civil settlement, and you've done many of them, obviously, there is a provision in the settlement agreement which says that neither side admits liability, or words to that effect, correct?
Generally. Not every one, but generally that's true.
And essentially what that means is neither side admits wrongdoing, correct?
Correct.
And the confession of judgment has nothing to do with an admission of wrongdoing or liability.
Well, it would have the same impact if you had to file it. It would be a judgment for that amount. I don't know what impact it's going to later be. I've never handled a case where you filed a confession of judgment, and then somebody tried to use that in another case to say you admitted something. I frankly don't know the answer.
It's never used to say someone admitted something. It's simply used to collect the money you're owed, right?
Sir, I just told you, I've never researched that issue, and so you got the wrong person. I've never had someone where I had to go use it. I didn't have to use it with Mr. Jackson, so I can't tell you the answer. I know it is. My concern was the making sure, if the money wasn't paid by Mr. Jackson, we could go into court and start seizing his assets. That didn't happen. He paid. It never happened.
Would you agree that in many civil settlements of civil cases, you will have both the provision that says neither side admits wrongdoing or liability as well as a confession of judgment?
It's rare you get a confession of judgment. It is very typical that you get neither party admits wrongdoing in a release. It's typical. You don't need the confession, because you usually exchange the release and the money at the same time. So there isn't that issue.
But you need a confession of judgment if you want to secure payments to be made in the future, right?
That you need. That's right. And that's what we got.
And if payments are to be made in the future by any settling party, you would almost be foolish not to have a confession of judgment, correct?
I don't know. We'll let somebody else worry about who's foolish. We did it. We thought it was the appropriate thing. We demanded it. We got it.
Please answer my question, Mr. Feldman.
I don't know what's foolish for lawyers to do. I mean, I haven't thought about it. It's a good practice. I did it, to get it. I mean, I demand to get it for my clients. That's all I can tell you.
You demand to get it for your clients because if payments were to stop, you would have a faster way.
Sure.
To obtain that value than you would if you had to sue for breach of a settlement agreement, right?
Yes. That's what I think I'm saying.
And when you have your clients get a confession of judgment in a settlement agreement in a civil case, typically there also is a provision where neither side admits any wrongdoing to each other, right?
The settlement agreement will say that. That's correct.
And that's what you had in 1993 in the Chandler case, correct?
We had the settlement language that said that, and we had a confession of judgment.
You had settlement language that said neither side admits wrongdoing to the other, and you also had the confession of judgment you just described, true?
True.
Now, did I hear you say, in response to the prosecutor's questions, you stopped representing Janet Arvizos in the fall of 2003?
The first time.
Pardon me?
The first time.
That's the first time you stopped?
That's the first time I stopped.
Okay. Now, as I look at pleadings filed by your law firm in this case, I count no less than 4 lawyers representing the Arvizos well into 2005, correct?
That's why I answered the question the way I did. I said that's the first time that I terminated the relationship with Ms. Arvizos.
And in 2005, you have represented the Arvizos in documents filed in this particular criminal case, correct?
Correct.
A lawyer named Julian Brew from your firm has also represented the Arvizos in documents filed in this criminal case in 2005, correct?
Well, my law firm, because of me, has done this for the Miss Arvizos. We've done it for her parents, and for the newborn baby. I think those are the 3 people. But I may be wrong.
Let me rephrase the question.
Mr. Brew works for me. I mean, I don't want to demean him. I mean, he works with me.
Mr. Brew is a lawyer with your law firm, correct?
Yes.
He has represented the Arvizos in the year 2005, correct?
The law firm has represented her, and he's one of the people, to be technical.
Sir, you work for or your partner with approximately a 600-person law firm, correct?
He's one of the lawyers that worked on this case. That's what I said.
That's Julian Brew, correct?
Yeah.
A lawyer named Theodore Maya has also worked for the Arvizos in the year 2005 in this case, true?
True.
A lawyer named Robert Turner has also worked for the Arvizos.
Yes.
In this case, correct?
Correct.
Those are 4 lawyers with your 600-plus law firm, true?
True.
All right, it's break time.